Hello, so today I'm going to go through your questions that you've submitted. I'm going to try to make this the easiest video to edit possible, but sometimes I will break away from this screen to show research. I've not prepped anything at all, so I'm just answering these questions off the top of my head. I don't know how long it's going to take. I feel if it's taking too long, I might miss some of the questions and make another video in the future. I'm sure there'll be another question and answer video in a couple of months. But hopefully I'll get through all the questions. We'll see how it goes. I've never done anything like this before. I don't have any expectations about how long it will take. The first comment that I've highlighted here is for a reason that I want to explain something to you. So this comment is, thanks for the interview. Please don't be so insistent on presuming good faith on the part of anyone involved in the scapegoating of Lucy Letby, even her own counsel. It's their job to prove they did their jobs correctly as the common man would define it. There's way too much testimony evidence indicating that key players were not acting in good faith, as opposed to just being stupid. So there's a couple of things I want to say about this. Firstly, there are certain things that I can't talk about currently for reasons that I can't discuss. So there is a good reason for that, and hopefully it'll become apparent sooner rather than later. The second thing is that I have to be very careful about what I say online, both from a legal point of view and also because my name will be indelibly associated with this channel forever once my name becomes more public. It's already public now, of course. So sometimes people say things in the comments that I may agree with or that I may think are credible, and I will typically... Sometimes I won't respond at all, or I have to respond in quite a guarded way. I just have to be very careful about that because, you know, while I don't think I've ever done anything controversial online, I guess this is kind of controversial in and of itself, but, you know, everyone has seen stories of people being burned by something they did 10 years ago. I saw an example of that recently. It's a really trivial thing. It's from some stupid channel about football, and one of the girls who was on it years ago, she made some pretty dubious comments about black people, and now she works with loads of black people. It's going to be very difficult for her to come back from that. Now, obviously, I haven't done anything like that, but if I'm seen to endorse something that, you know, is not, you know, I have to be careful about endorsing things that would backfire on me later anyway, or I have to be particularly careful about endorsing things that are potentially libelous. Even though I won't say anything libelous myself, if I'm seen to approve of something that is libelous, then that might not be a good idea. So I'm very careful about that because, you know, it's important. But then in addition to that as well, I do want to lean a little bit towards assuming that people acted in good faith. If we can show evidentially that's not the case, then we should definitely show that. As I say, I can't actually go into that at the moment because for reasons that I can't discuss. But I just wanted to explain that firstly and make that crystal clear. So I'll go on to the first question. I'm so grateful I found your channel. I heard you mention that you wrote a book. What's it called and where can I purchase it? Thanks for your hard work. So I mentioned this question first because it's probably the most asked question. So the working title of my book is Failed to Put Capitals On, Reasonable Doubt, Examining the Conviction of Lucy Letby. So I don't see any reason publishers will object to that. So there's a good chance that'll be the final title, but I can't say definitively that it will be because publishers like to have a say in things. You can't purchase this book yet because I finished writing it. I finished writing it quite a while ago, but I'm working on some stuff in the background to do with publication to make sure it can reach the widest audience possible. When I'm able to announce this, people will understand why I did it, and you know, I think they'll be pleased to hear the news, but I'm still working on that phase. I already have publishers interested, so I could have already had this. This could be going to the publication phase now. It's not because I'm working on this stuff in the background, partly to make the book as credible as possible, but also to give myself the biggest amount of options in terms of publisher options, basically, or agent options. It's good to connect with agents as well. For this book, it's not entirely necessary because I've already got publishers interested, but I will try to connect with agents as well. So having one thing people possibly don't know, unless they've seen my speech at Hereford, is that excuse me, I do have this problem with my throat drying out. It's really annoying. Unless people have seen my speech at Hereford, they won't know that I've been, ghostwriter for a very long time. I've been a freelance writer for 15 years, and I've ghostwritten and edited over 50 books. Slowed down a bit in the last couple of years because I've been concentrating on this. So I'm fairly experienced as a writer, but also I know a fair bit about publishing. So I could have written a book before now, but I wanted to write one at a time when it could achieve mainstream penetration and make a difference, not just be online, be reviewed by people who are interested in the case, and not really be known about by anyone else. So I knew what had to happen in order for that to occur, and then when the time was right, I started to research. When I've been researching, obviously, before I started writing, but then I completed the writing. So hopefully it will come out. I mean, it's very, very likely to be next year. It's not going to be coming out this year because I've had to delay things, but yeah, it'll be coming out at some point next year, and I will update people via the channel so they know about that. What are you going to do with all your analysis into getting Lucy Letby a new trial, if that's your goal, and how are you going to do it? Do you intend to publish your findings in the mainstream media? Provide your documentation to Dame Vera Baird, who has recently joined the CCRC. You'll appreciate I'm asking these questions because it is vital, in my opinion anyway, that your incisive, informative analysis is placed in the hands of the decision makers. Well, it's very kind of this person, firstly, to say that. So there's a few questions to answer there. Firstly, I don't think there will be a retrial of this case for reasons that I've explained previously. I think it would be far too embarrassing for the Crown Prosecution Service and possibly other organisations and institutions. And on the very first day, the defence can call statisticians and trash the statistics chart. And after that, there is no prosecution case because the prosecution case is completely reliant on that statistical chart having some credibility. It's not going to have any credibility. So almost then, immediately, it's almost like a mistrial. I mean, it isn't really a mistrial because that's happened for some technical legal reason, but it's a trial that has no credence at that point immediately, before you even look at the science. So I don't think there will be a retrial of this case. I think convictions will be quashed. It's just a case of ensuring that those convictions are quashed sooner rather than later, because it's clear that the evidence that's gone into this court case is total bunk from start to finish. So my goal really would be to quash the convictions. In terms of publishing the findings, of course, as I mentioned, I'm writing a book, so that's really, the aim is to get that into the mainstream. I would be doing interviews at that time. We'll have to see what happens, but I'm connected enough now that it will be reviewed in the mainstream. I will do mainstream interviews, etc., etc. I don't know what that's going to look like exactly. It's a slightly daunting prospect for me, but I'll be absolutely fine. I'll just crack on with it. I decided when I started this that I just need to give everything, pedal to the metal for Lucy's well-being and to make this a success and to get to our ultimate goal. So whatever I have to do, I will do. It's possible that I'll write articles in the mainstream media at that time as well. I don't know. We'll see. In terms of providing documentation in the defence, I can't really discuss this at this time. That's all I'll say. Why didn't Lucy's defence call any expert witnesses? And then the next question is exactly the same. Why on earth did Myers not call any expert medical witnesses? It makes no sense. Why not call the original pathologists? I think, though, it is important to point out that Myers had wanted Dr. Hall to give his expert testimony, but wanted it done after the prosecution had put forward their case for each baby, but Judge Goss refused that. I think that decision by Goss had a significant impact on how the trial went. So I think that's a fair view. Obviously, I have been critical and would be critical of many decisions made by the judge in this case. I think almost every decision made by the judge went in favour of the prosecution, if not literally every decision. I think it's an extraordinarily jaundiced process in that respect, and that may have had an impact on what Ben Myers did. I still cannot see any conceivable reason why you don't call Professor Hall. I believe it's not Dr. Hall, actually. I've heard lawyers try to explain why, but at the end of the day, you need to get some science in the court case. But if he's going to be very cautious, then maybe he thought that would backfire. Maybe he thought it was better to just attack the prosecution witnesses. However, the most important thing for me is that Professor Nina Modi wrote to the defence, and other people also wrote to the defence, and never received any response. That is incomprehensible. I can't begin to defend that or give you a reason why that would occur. I don't know any better than anyone else. No one will ever know, because Ben Mize is never going to talk about it. The instructing solicitors, never going to talk about it. We're never going to find out anything about that. So there's literally no way of knowing. All I can say is that if you have someone in the credentials of Nina Modi contact you and you ignore her to the extent where she says, "I never heard back from them," that is very poor conduct, I would say. I can't see any possible defence or any possible argument that could be made in favour of that action. It's just plain wrong, in my estimation. I'm going to look at this link now that I've put in brackets here from the Criminal Bar Association, which is also of some relevance. So I highlighted this article from the Criminal Bar Association in a previous video, and they talk about how difficult it is to instruct experts on behalf of the defence in a criminal trial. It's professionals. Someone has explained in some detail to me, who is very experienced in this field, who has been acted on behalf of the defence in a criminal trial, all of the reasons why professionals don't want to do this. Firstly, if you're defending someone like Lucy Letby, who's been accused of child murder, it's reputationally risky. Regardless, I guess if the person is exonerated, then it might not hurt your reputation. But even we've seen with NHS nurses who worked at the hospital, Countess of Chester, they were told not to give evidence. So obviously the fact that Lucy was going to be found guilty was not decided at that point, but they're saying it's going to harm your career, whatever you do. So there's that, firstly. It's a huge reputational risk. The second thing is you don't necessarily gain any remuneration from this process, or it could be very minimal. So it's a lot of work for not much reward, and then you can lose. The person can go to prison. You've damaged yourself reputationally for nothing. The third thing is these people are typically very busy, so they don't have time to look into the case anyway. Unless there's something that is a red flag immediately, or they're particularly experienced in this field and they realise how many miscarriages of justice there are, all they perhaps see is the headlines, and the headlines may make the person look very guilty, or they might be way too busy in their field to even really give it any serious consideration. I think Richard Gill, in fact, said when he first heard about Lucia de Burt case, he was very immersed in his complex mathematical and statistical work, and he wasn't. I think I'm right in saying he wasn't particularly taken with the case at first, and it was only when someone made him have a second look at it he realised. And then because, firstly, ethically and morally it's a bad thing to happen. Secondly, I think he's very passionate about his area of science and expertise being misused. So then he became an advocate for that field. But if you're working in medicine or nuclear physics, it's a pretty all-encompassing undertaking. It's not something you can be half-hearted about. You need to be fully committed. So you may not even notice the case in the first place. It's then very difficult for the defence to just identify some random person working in academia or, whatever field it may be, but from a professional background, who would be willing to come in, who understands the case, who can take time off work, who wants to do it, etc., etc., etc. So there are all these very, very numerous barriers towards attracting defence witnesses. And then on top of that, there's the case of Wayne Squire. Let me just find this quickly, actually. Because there's a BBC article that is very illustrative. So she was struck off over shaken baby syndrome. So this is as mainstream as you get. So it's the BBC. This is a rare occasion of the BBC saying something relevant. So credit to them. They wouldn't do this now. I'm pretty confident even by now they probably wouldn't print this article. But anyway, there's a lot of she says here. So there's Dr. Squire, Dr. Cohen, and Dr. Scheinberg agree that evidence which supports the theory just isn't there. The problem is that in 40 years we've not been able to demonstrate the traditional theory of shaken baby syndrome. Dr. Squire is less diplomatic. Shaken baby syndrome is rubbish. There is no evidence to support this hypothesis of shaken baby syndrome, and yet it is still being used every day in our courts as the basis on which some very important decisions are made about whether people may be sent to prison or babies taken away from their families. There is no scientific evidence to support it. There never has been. It is not right that it's still being used in the court if it has no validity. So, firstly, I'll just say briefly, there are people all over the world that are in prison for shaking their babies. And this is a scary thing because your baby can die, so you're devastated, obviously, and then you go to the hospital. All it takes is for one doctor to say, I think this baby might have been shaken too hard. And then all of a sudden, you're not in a hospital or you're not being counselled, you're in a police station. And it can all, as we've seen with Lucy, it can rapidly descend from that point. And it has for many, many people in this country, in Europe, in the United States, in Australia. I don't know so much about Asia, Africa, etc. But in what we consider to be the developed world, there are many people in prison and have had the children taken off them because of so-called shaken baby syndrome. I was at an event in the Francis Crick Institute that I've mentioned before, and there was a French lawyer who stood up who was representing an extraordinary number of clients. I think it was over 100 who've been convicted of shaken baby syndrome. That there are moves now occurring in the United States, in some states anyway, to eliminate this from the court system, and I believe that's already happened. But in this country, you can still go to prison. You can still have your child taken off you because of so-called shaken baby syndrome. So what is significant about this? So we'll keep going down. Right. So this really sickens me. Not just because of the specifics of what happened, but because of something that I'll go into as well. But the original complaint against Dr. Squire came not from a fellow scientist, but the Metropolitan Police. In 2010, Detective Inspector Colin Welsh, who has since retired, told an SBS conference in the United States that defence witness testimony was at the top of the list as a reason for the police losing child abuse cases in Britain. In his address to the conference held in the US state of Georgia, DI Welsh reportedly suggested some tactics to question everything about the defence experts. These included questions about qualifications, employment history, testimony, and research papers presented by these experts, and even going to the professional expert bodies to see if we turn up anything. A spokesman for the Metropolitan Police confirmed that the then DI Welsh had given the speech, but said it was completely committed to the judicial process and would never seek to improperly influence it. If it was the police's strategy to improve its conviction rate in SBS cases, it may have succeeded. But now Dr. Squire is calling for a public inquiry into SBS, and a battle to save a good name is shining a light on a hotly disputed area of medical science, except that hasn't happened at all, because you can still go to prison for SBS. And it hasn't changed, nothing has changed since this article was written 9 years ago in the slightest. But this really, obviously, what he's saying there is morally and ethically despicable, but this kind of thing really sickens me, because Detective Inspector Colin Welsh, who is obviously a moron, he is in a position of influence, or was in a position of influence. Now he's an absolute nobody because he's retired, and the supposed power that he thought he had has just disappeared because he's not wearing a uniform anymore. But this is emblematic of a fundamental societal problem that I've kind of investigated in the past, and it is kind of a very deep-rooted, ingrained belief that certain sector of people will have in just authoritarianism. So it's like almost like a might is right theory. So like we want to convict people, so we just should, and if we convict more people, that's a good thing. It's like this absolutely blind belief in the mechanisms of the police and the mechanisms of the criminal justice system, and effectively the mechanisms of the state. And note that it's not about winning the scientific argument. It's not about proving that shaken baby syndrome is actually correct. It's just about getting a conviction, so we can say, look, we convicted someone, we got a result, we're in the right. We must be right because the person has been convicted. It's that blind faith in power that some people have. So Detective Inspector Colin Wells, he's probably like playing bowls now or something, like going on about, oh, I used to be in the police, I used to do this, I used to that. It's just a very. I mean, I could talk about this topic for quite some time. I don't really want to because it's not really on topic. But it's just there is this idea, and you find it's really really difficult when you speak to these type of people to make them understand that authority and power can get things wrong and does get things wrong and is not immutable or should be challengeable, and that finding any way to secure a conviction is not the job of the police. That is emblematic in this case. It's emblematic in Lucy Letby's case. 2016, this article was written. This was just when Lucy Letby's situation was beginning to unravel. That's the year she's taken off the unit. And everything we've seen from Cheshire Police, the Cheshire Constabulary, runs concurrent, parallel to what we've seen here from Detective Inspector Colin Welch. Like, we should just do anything we possibly can to get a conviction. Why that? I think that's partly occurred because of attitudes towards what I would call authoritarianism, or the pedestalization of authority, putting authority on a pedestal. I think that's part of the reason. I wonder if there are other aspects. For some reason, at some point, the police, whether it could be many years ago, it could be decades ago, they've just decided, for whatever reason, I don't know if it's a state-driven mandate, or if a certain sort of people join the police and then there's like a culture that develops because of a collective mindset. I don't know what it is, but it's clear that the police see their job as just banging people up. They think if we put someone in prison, we've succeeded. This is a very clear indicator of that. And that's something that needs to change. I don't know how it can change because it's now absolutely ingrained in the police across Britain and if not the world. But certainly we should just look at Britain because this is a British case. I think it's undeniable that the police seek convictions basically at all costs. And that's very worrying. So why was her defence so bad? I've pretty much answered, but I'll just say mitigation, that despite the very clear and legitimate criticisms of her defence, the cross-examination of the expert witnesses, particularly Evans and Bohin, was a lot more successful than other strategic aspects, and you'll see that in future videos and probably some videos that I've made already. Next question is it true that consultants were doing reduced ward rounds? That's absolutely true. Not only has this been confirmed from documentations and media reporting, but I've spoken to people affiliated with the hospital and we know that this is the case. They were doing very significantly reduced ward rounds. And it's clear that the registrars had a disproportionate amount of responsibility on that ward, and that would apply probably for a level 1 unit, let alone a level 2 unit, let alone a level 2 unit that was taking level 3 babies. So that was potentially calamitous, and indeed it had calamitous consequences. At 7 minutes 35 seconds, you show a Telegraph article, hospital told nurse she shouldn't give evidence. Surely this is witness tampering or perverting the course of justice. So we're going to go into a discussion of witness tampering. I would suggest that it technically isn't witness tampering as such, because in order for something to be witness tampering, there needs to be an explicit act that has been witnessed by someone. So this person is giving character testimony, as far as I understand it. So in the Daily Telegraph article, that is what is indicated. So character testimony is not a witness. If say, for example, the incident with Dr. Jayaram, where the tube was supposedly removed, although it obviously wasn't, let's say she had witnessed that and given a different account of events, then the hospital said, don't go into court, don't do that, we'll sack you, blah, blah, blah. That would be witness tampering. I think to go into court and say Lucy Letby was a good nurse, blah, 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 I believe she's innocent, etc., is not witness tampering. It's morally and ethically reprehensible. I don't think it counts as perverting the course of justice. I don't know what counts for perverting the course of justice, but we'll just now examine what the precise definition of witness tampering and perverting the course of justice are, because I simply don't know. So I'm just going to go through these quickly. Witness tampering is the act of interfering with a witness's ability to provide truthful testimony in a legal proceeding. This can involve threats, intimidation, bribery, or any attempt to influence a witness's statement or prevent them from testifying truthfully. So, intimidation, bribery, misleading conduct, preventing testimony. Witness tampering undermines the integrity of the legal system by potentially leading to false or misleading information being presented in court, which can affect the outcome of a case. It's considered a form of obstruction of justice. So, I think, as I say, this would apply, excuse me, this would be considered witness tampering, what occurred. However, it's not witness tampering because the person isn't a witness. So I don't know what the kind of, if there is a parallel thing of discouraging someone who's going to be a character witness, but I don't think this would count as witness tampering because they haven't witnessed anything. I think is the simple answer. So move on to what is perverting the cause of justice. Perverting the cause of justice is a criminal offence that involves deliberately interfering with or obstructing the legal process. It encompasses a range of actions aimed at hindering investigations or prosecutions, including fabricating or destroying evidence, intimidating witnesses or jurors, or providing false information to authorities. Essentially, it's any act that is intended to mislead, obstruct, or interfere with fair administration of justice. Here's a more detailed explanation. Key elements: interference. The act must be one that interferes with or obstructs the legal process. The act must be done with a specific intention to mislead or prevent the proper administration of justice. Mere negligence or inadvertent actions are not enough. The act must have a tendency to pervert the cause of justice. Examples are fabricating or destroying evidence, intimidation of witnesses or jurors, providing false information, assisting someone to evade arrest, lying to the police. So obviously this would be the most likely. Intimidation of witnesses or jurors. Perverting the cause of justice is a serious offence, often carrying a maximum sentence of life imprisonment. According to Jeff White solicitors, the specific penalties will depend on the nature and severity of the offence. These specific penalties will depend on the nature and severity of the offence, the extent of the interference, and the impact on the judicial process, according to LexisNexis. So there's definitely potential for this to be perverting the course of justice, but I would question whether it's clear enough. So I've asked this question here. If a hospital advised a nurse not to give character testimony in favour of a defendant in a court case, would that constitute perverting the course of justice? Advising a nurse not to give character testimony in favour of a defendant in a court case could potentially raise serious ethical and legal concerns, but whether it constitutes perverting the cause of justice depends on several key factors. So there's a further explanation of what is perverting the cause of justice. Key questions in your scenario. Was the nurse a witness under subpoena or expected to testify voluntarily? If the nurse had already been called as a witness or had volunteered to provide truthful evidence, was pressured not to testify, this could be construed as witness interference. So that doesn't apply. So she's not under subpoena and the process hadn't been established yet. So that's the first thing. What was the nature of the hospital's advice? If the hospital simply discouraged the nurse, e.g. citing reputational concerns or internal policies, it may not reach the threshold of criminal interference. That's probably your answer immediately. If the hospital threatened retaliation, e.g. job loss, or coerced the nurse, that could be considered an attempt to interfere with justice. So they probably knew exactly what they were doing. They probably knew they couldn't do that, and they probably knew they could do the first thing, which is probably exactly why they've done the first thing. Was there an attempt to conceal relevant information? So yes, but I think at this point we can rule out that this was perverting the cause of justice. It just doesn't reach the threshold for that. So that would answer your question. It's ethical. It's ethically dubious to say the least. It's pretty despicable in my view, but it's not probably witness tampering or perverting the cause of justice. So next question. Lucy Letby not initially passing a final student placement. Was this an interpersonal thing between Lucy Letby and her assessor or something else? Was her placement at the County Chester Hospital in the neonatal unit or somewhere else? When Lucy Letby repeated her final placement with a different assessor, was this in another unit, another hospital, or the County Chester again? So the first thing is that it's a matter of opinion whether this was an interpersonal thing between Lucy Letby and her assessor or something else. There was one mistake pointed out that she made with regard to the measurement of something, which is a serious error. But this is why you're a student, so you can learn things. You're on your placement to iron out these errors and iron out these mistakes and become a competent nurse. As I've shown in a previous video, no one denies or no one doubts the fact that she was a competent nurse. In fact, she was very highly regarded on the unit. So she'd ultimately been through her training and her education and become a nurse and become what was regarded to be an excellent nurse. So I do think there's actually evidence that there was an interpersonal problem here. I'm not saying that the assessor disliked Lucy, but I think they perhaps misinterpreted aspects of her behaviour because they described her as cold when other people that knew her better say, well, that's simply not the case. I think that the assessor perhaps misinterpreted shyness as coldness. And she's perfectly entitled to her interpretation. She's the assessor and she's entitled to a view, but Lucy very quickly passed her assessment with a different assessor literally weeks after that. So I think there is a degree of interpersonal, if not conflict, misunderstanding at the heart of those reports. She did work at the hospital in Liverpool, Royal Liverpool, but this assessor was Nicola Lightfoot, who worked at the Council of Chester. So it's never been made, I think, 100% clear as far as I'm aware, but I believe that aspects of this placement where she failed was at the Council of Chester. I would assume that it was on the neonatal unit because she became a neonatal nurse, and working with other infants just isn't the same. I think her placement at the Liverpool hospital was part of her overall education, but when this assessment was taking place, that would have been in Chester. And again, when she repeated her final placement, that would have been in Chester as well. I think the placement at Liverpool is essentially for work experience. What's interesting about that is that it was a level 3 unit, and so because she'd had quite a lot of experience on a high level unit, when she came back, she was entrusted with a lot of responsibility. Ironically, that could have been what finished her off, really, because she ended up doing more shifts, being given the sickest babies, and then we know what the consequences of that were. Disciplinary issues with Lucy Letby and her manager when they gave incorrect dosage of medicine to a patient. How serious was this? So this references what I just mentioned, where Lucy gave incorrect dosage of medicine to a patient. I don't think they gave it. I think they measured it incorrectly. They didn't actually give it. It was a mistake that was spotted, and then it never occurred. So it's important to emphasise this occurred when she was a student. So, as I say, she was learning. There's no indication that when she was a nurse that she made mistakes or was considered incompetent. Quite the opposite. So, with regards to this, the first thing that I would say is that I'm not the best person to give an assessment of this because I'm not a nurse, I'm not any sort of medical professional, so I can only give my unqualified opinion. I think that it was quite serious because clearly you don't want to give someone an incorrect dosage of medicine. I can recall an incident that occurred at a hospital where someone, I remember hearing about this, it would be like 15 years ago now. I'm not sure why lorries decided to reverse outside my house. It's pretty annoying, but hopefully it'll go now. Hopefully, I'm sure you could hear that. Yeah, I remember hearing about this incident 15 years ago where someone accidentally gave an infant, I believe it was, 10 times the dosage of a medicine than was needed. And by the time the error was recognised, the patient is just dead and there's no way they can do anything. So potentially it's very serious, undoubtedly. I don't think that can be denied. What I think is interesting about this incident is that this is a medical error. So throughout the court case, we see everything being attributed to malice, and there is never anything being attributed to medical error, when in fact medical errors happen all the time, even on competent units. We're all human beings, and we're all fallible, and we'll all make mistakes. That's inevitable. So the fact that Lucy Letby made a mistake is serious, but it was not anything out of the ordinary, and it's not anything that we shouldn't expect, because that's what people do. People make mistakes. And the whole point of doing a placement, the whole point of studying, is so that you try to iron out as many mistakes as possible. You will still make mistakes in the future, just as the doctors made mistakes on this unit, just as nurses made mistakes on this unit, just as I make mistakes in my job and in work that I do. Everyone that has ever lived who's a human being has made mistakes. You know, for example, in sport, if people didn't make mistakes, then it'd be pointless to watch, because every football match would be 0-0 for starters, and every time, say there was a tennis match, the favourite would win every single match, and it would just be tedious. We know that doesn't happen. Some days you get up and you play badly, or you mismeasure something on the unit, or your mind wanders, you don't mean it to, but you lose your concentration, or you're recording a video and a lorry does a 3-point turn outside your house making loads of background noise. All of these things can happen quite easily. So, I wouldn't be too hard on her for this, because we all make mistakes, but I think we shouldn't downplay the seriousness of it. I think the reporting of it was perhaps irresponsible, because again, it was attributed to, yet again, this was like, oh, this is sinister. Why has Lucy done this? Was she trying to poison someone even during her placement, when there's just no evidence for this? This was just a mistake, the kind of mistake that happens in hospitals all the time. That doesn't mean that we shouldn't take them seriously when they happen, but they're basically inevitable. How was Lucy Letby viewed while on secondment at Alderhay Hospital? Were any issues flagged there about her behaviour competence? So I thought she was at I didn't think she was at Alderhay. I thought she was at the other one in Liverpool. But the only thing that's been flagged is this stupid issue about tube extubations. That's just disappeared now because it's rubbish. But we'll be coming into that later, because I know there's a question on this later on, so I won't go into that too much at the moment. There are comments from the Thirlwall inquiry, from documents from the Council of Chester, official documents, which indicate that Lucy always collaborated extremely well with other hospitals and other teams, and was highly regarded by everyone that she came into contact with. You can't find anyone saying a bad word about her. You literally can't. It's insane. She was very, very highly regarded on the unit. She was very, very highly regarded when she worked on other units. She was very, very highly regarded by parents. So I've demonstrated all this in previous videos, but no, there's no issues flagged, nothing of any credibility whatsoever regarding behaviour or competence. When you do your Q&A video, would you be able to explain waive privilege and also how it could affect Lucy's case? I've watched a video by Art of Law and I'm none the wiser. So I've really been looking forward to this question, because obviously the legal system is quite arcane. As I was mentioning when I was talking to Richard Gill, this is a very antiquated system that has barely changed in literally centuries. It's crazy how little it has changed, given how much society has changed. When it goes back so many centuries, but even reformation of the system has been virtually non-existent since Dickensian and Victorian times. Even though at that time people had never even seen a car before. People didn't have electricity in the houses. People were pissing in the street. Like, there was no sanitary condition. Like, infant mortality. Like, you had an infant that just basically died. Like, it was one of the things I always like to cite. I've probably cited this in other videos. Like, Mozart, his legacy didn't live on because all his brothers and sisters died, apart from, like, I think 4 of them died very young, and then 2 of them never had children. So he didn't even carry on for one generation. So comparing that society to the society we live in now, this hugely technological information age, it is completely different, and it's very clear there needs to be significant reform of the criminal justice system. However, I will now attempt to explain the waiving of privilege. So I also watched the video referenced in the question, and I must say that it wasn't made particularly clear in that video. So I'll just read this here, which I think is the best definition of waiving privilege and explanation that I've seen. A party may choose to waive privilege in a document or part of a document which is helpful to its case. However, this can be risky, as if the party relies on the document in support of its case, it can result in the party having to disclose other privileged documents or the whole document. The general rule is that where privilege is waived in respect of one document in a set of documents, then the class of documents will have to be disclosed unless the document disclosed deals with an entirely different issue or subject matter. That's extremely technical, it doesn't really matter. This is to prevent parties unfairly indulging in selective disclosure or cherry-picking among the privileged material. Privilege can also be waived by reference to the contents of legal advice in witness evidence, opening submissions, and expert reports. In PCP versus Barclays Bank, the claimant was entitled to further disclosure on the basis that Barclays had waived privilege as a result of their reference to legal advice in witness evidence on opening submissions. And in Pickett versus Balkins, an inadvertent waiver of privilege was held to include the disclosure of otherwise privileged communications with the claimant's own expert. So, let me explain this issue for you in simple terms. So, firstly, before we go any further at all, we don't even know whether or not Lucy Letby has waived privilege. We don't even know. But I'll come back to that in a second. Waiving privilege could potentially be a problem for a defendant if it resulted in them revealing information that was helpful to the prosecution. So that would be an incentive for someone to avoid waiving privilege, of course. In this case, it's phenomenally unlikely that that is of any significance because Lucy Letby has always maintained her innocence, and it's very unlikely that there's any discussion with her barrister or with medical experts that give any indication of guilt or provide any information that will be useful to the prosecution. So this is just essentially a red herring. It's of no importance whatsoever. When Lucy Letby is required to waive privilege, she will. She may have done that already. We don't know. The people that are saying this, the only reason that they're saying it is so that they can pretend to have something relevant to say that they've come up with themselves, even though usually it's people that have no legal qualifications. It really has no merit as an argument whatsoever because Lucy will waive privilege if it's needed, and it won't help the prosecution in the slightest. So it just has no relevance to the case at all. It shouldn't really even be addressed because it's just a legal formality. That's all there is to say about it, really. People that are, as I say, using this are just trying to use it to try and say, oh, look, here's something original I've had to say because all I'm doing any other time is repeating the prosecution case because I don't have any research skills, I don't have any work ethic, I don't have any discipline, I don't have any knowledge, I don't have any qualifications, I don't have any credentials, but I can't just sit there repeating the prosecution case as it's being systematically demolished. I've got to say something to try and make it sound like my opinion is credible. So they bring this thing up about waiving privilege. It's completely meaningless. It means absolutely nothing. It will have no impact on this case whatsoever. So the next question is, do you know anything about Lucy Letby's reporting of safety incidents through Datix? Now, I'll probably do a standalone video about this at some point. I have mentioned it in previous videos, but everything indicates that Lucy Letby was the most scrupulous and professional user of the Datix system at the hospital. Now, there are potential issues related to Datix in that I have been informed, and there is quite strong evidence for this, that consultants generally do not like you to use the Datix system excessively, or what they would deem excessively, but what you might actually just describe as thoroughly or professionally. Even though you're supposed to do this, but they don't like being picked up on things, and they definitely, many consultants would not like being picked up on something by a Band 5 nurse. It is possible the fact that there is explicit evidence in the Thirlwall inquiry that Lucy fills in Datix information very diligently and has picked up consultants. And actually, one of the things that Arian Powell says is that Lucy will even Datix herself. So she'll say things about herself that other nurses will not do. So everything indicates that Lucy is the most diligent reporter of safety incidents through Datix on the unit. And I've had neonatal nurses look at this, and I've had neonatal nurses look at all the Datix information that is available, and they absolutely endorse that view. Was there any negligence claims or complaints from parents on record about the care of mothers or the babies received? Yes, there was. I'm not going to go into this into great depth because this negligence claim is going to be a long way down the road, given everything that's going on at the moment. But there was a negligence claim already in process by one of the infant's parents in this case. I think it was either child C or child D. I forget precisely which one it was. It doesn't really matter now because that's obviously in hiatus for quite some considerable time. But it's notable, this hospital has paid out negligence claims many times, in common with many other hospitals. There was the case of Noah Robinson, where they made massive blunders. There are other cases on the neonatal unit where they're known to have made blunders. I can't make any further claims about that, comments about that for legal reasons, but yes, there were negligence claims that were being advanced at the time of Lucy being fingered. Lucy Letby's nursing colleagues rated her highly, including managers, but some consultants campaigned against her, unsuccessfully, as the grievance showed. Why? This is a question that I cannot answer at this time for legal reasons and various other reasons. I would love to give a full picture on this, but I can't currently. Hopefully, everything will come out related to this in the relatively near future. In terms of why they did this, I can just say that the Datix could be a possible reason. It could just be when we say that Lucy Letby was scapegoated, it may not have been deliberate. It may not have been a conscious process. It may have just been unconsciously they saw her around a lot, then they became obsessed with it. It's a typical error of human reasoning. I don't think anyone, in fact, has a definitive answer to this question. We may never know why they decided to do this. We may never know whether it was a mistake or whether there was a slightly malicious aspect. There's simply no way of knowing. I've never accused them of having a malicious intent because I can't prove that. I don't know whether it's the case. It's just no way of knowing, simply. I keep wondering about the clip I always see making the rounds of the Court of Appeal judge criticising the reliability of Jayaram's witness testimony. Where did this fit into the trial's timeline? Is this part of the refusal of her appeals? If so, is there more publicly released of that process? Is it usual in the UK to release video clips of denied appeals? And why did the judge's opinions not suffice for grounds to appeal? So, let's go over this bit by bit. Which question shall I answer first? It is part of the refusal of her appeal, yes. This, in the judgment, the Court of Appeal judgment, this comment was made about Jayaram, that I'll go into shortly. If so, is there more publicly released of that process? I believe the entire video is available. I haven't watched that video because I knew her appeal would be released and I didn't want to watch the whole thing. I'm fully familiar with the Court of Appeal document. Something that I could do at some point is go through the whole Court of Appeal document and analyse it. It's one of many things that I could do on the channel. I may do that. I've wanted to do other things that I can't do for legal reasons, for other problems at the moment that I haven't done. That may occur one day, we'll see. Is it usual in the UK to release video clips of denied appeals? I believe that it is. I think, as far as I know, the appeal court is recorded all the time. I know that was true for Colin Campbell's recent appeal. I think the appeal process is recorded. Why this is recorded and why the Crown Court isn't recorded, I don't know. I believe the Crown Court should be recorded, as it is in the United States. I believe all court proceedings should be recorded, and we wouldn't have this farcical situation with the transcripts. And of course, a recording is so much more powerful than a transcript, because you see what actually happened in the court. So I believe, absolutely, all court proceedings should be recorded. Whether that will happen in my lifetime, I don't know, but I believe that it should happen. Why did the judge's opinions not suffice for grounds to appeal? So the opinion on Jayaram was just one aspect of the judge's opinions. The judge also gave numerous reasons why the appeal should not be allowed, so that was ultimately why the decision was taken. So lastly, I'll go through what was said about Jayaram in the Court of Appeal verdict. So I'm now going to read to you paragraphs 138, 139 from the Court of Appeal verdict, published on the 2nd of July last year. Mr. Johnson further submits that Dr. Jayaram's evidence as to the discoloration which he observed on the skin of baby A, as noted at paragraph 51 above, could properly be accepted by the jury as fitting the description in the Lee and Tanswell paper. Dr. Jayaram had not initially mentioned seeing the discoloration he later described, and only did so after he had read the Lee and Tanswell paper. It was suggested to him in cross-examination that he had not in fact seen what he described. That suggestion was refuted by Dr. Jayaram, and Mr. Johnson submits that the jury were plainly entitled to accept the doctor's evidence. It was only when he read the Lee and Tanswell paper that he realised the full significance of the striking discoloration he had observed. Before I read paragraph 139, I just want to emphasise again how important the Lee and Tanswell paper is in this court case. It's undeniable that it's critical to an enormous swathe of so-called diagnoses. There aren't any diagnoses in this court case, as I've said previously. There's just theories and hypotheses. There was nothing in this court case that even comes close to the bar required for diagnosis. But the theories and hypotheses that are put in this court case absolutely centre on this Lee and Tanswell paper that obviously now know Dr. Lee has said, well, everything they've said is bullshit, basically. So that must be emphasised. So paragraph 139. Save that the description of skin discoloration did not feature in Dr. Jayaram's clinical notes, we observe in passing that there appears to have been little evidential basis for the allegation implicitly made on behalf of the applicant that Dr. Jayaram had made up this part of his evidence. We also note that no similar allegation appears to have been made against the father of baby O, who, as set at paragraph 93 above, described his child veins as being bright, bright blue. So there is some criticism here of Dr. Jayaram. Of course, that didn't impact on the decision as a whole, but there was criticism of what he did, essentially, both in the court case and before. So then this is the Court of Appeal judgment for Child K after the retrial. This was published in October 2024, and I'm going to read you paragraphs 19 and 20. In our judgment, it is of some significance that the critical issue for the jury was whether they were sure of the evidence of Dr. Jayaram. But that's not really even the critical issue. I mean, this is the sole issue. There is nothing else other than Dr. Jayaram said, oh, I caught her virtually red-handed. Legitimate criticism could be made of his evidence. Although he believed that Letby had deliberately dislodged the endotracheal tube, he had said nothing at the time nor for many months thereafter. In fact, we know that it's over a year. There was an inconsistency between his evidence and the contemporaneous records. The nature of the case being considered by the jury was fact-specific. Had the jury known nothing of the outcome of the previous trial, the publicity surrounding it would have been a significant factor. Since the convictions were in evidence, the publicity was of far less effect. I mean, this is all rubbish, but never mind. The prejudice came from the jury knowing that Letby had been convicted of 14 offences of murder and attempted murder. That prejudice was outweighed by the probative value of the convictions. Had it been otherwise, the convictions would not have been admitted in evidence. I mean, this is just ludicrous. But fair to say here they're critical of Dr. Jayaram. Legitimate criticism could be made of his evidence. Paragraph 20. Before leaving the issue of whether Letby was able to have a fair trial, we must deal with the position of Dr. Jayaram. Mr. Myers and Ms. Clancy argued that the position of Dr. Jayaram was especially problematic. He had given evidence in the first trial when the jury had disagreed on the count where his evidence was critical. Following Letby's convictions, he had been interviewed by a variety of outlets and had commented on social media about the case. The schedule of material relating specifically to him indicates that he ceased to comment once it was known that there was to be a retrial in relation to the count with which he was particularly concerned. But the submission is that his public statements prior to that were extraordinary, given his position as a witness. We do not agree with that proposition. We have reviewed the material relating to Dr. Jayaram with care. We could not identify any matter relating to Letby which significantly departed from the evidence he gave in the two trials. He made comments about the extent to which those with overall charge of the neonatal unit bore responsibility for what had occurred. This could not have prejudiced the case against Letby. In the course of the retrial, Dr. Jayaram was cross-examined about what he had said in one interview he had given after the first trial. This was not in order to criticise the fact that he had been interviewed, rather the content was used to make a forensic point on behalf of Letby as to what the witness had said previously about her actions. So that's all a load of legal waffle, essentially. But the critical point here is that we have reviewed the material relating to Dr. Jayaram with care. We could not identify any matter relating to Letby which significantly departed from the evidence he gave in the two trials. Of course, since that was written, we now have this email in which Dr. Jayaram gives a completely different account of events. And bear in mind as well that over a year had passed before he even mentioned this tube incident. So that is one of the things that will undoubtedly be highlighted in Lucy's appeal. So moving on to the next question. Seems like if it came out over here in the US that material witness lied in trial, that would retroactively be declared a mistrial or at least trigger an automatic appeal. I assume this was before the infamous email came out, but this judge was already apparently onto at least Ravi Jayaram's shiftiness. His testimony surely had to have a huge role in at least the retrial of Baby K. It's hard for me to comment on this because I don't know anything about America. I'm not even particularly knowledgeable about the British legal system. All I can say is this is not going to be a mistrial, clearly. as to why that is, it seems to me that those that preside over the legal system can just make it up as they go along, really, and that there have to be extraordinary circumstances for something to be a mistrial, particularly in a case of this magnitude and prominence. So I don't think there's any prospect of a mistrial or triggering an automatic appeal. The system has been cast in stone for a very long time, and it's a very conservative society. I don't think that I'm going to discuss that at any great depth because it could go on for quite a long time. All I can really say is that there's no prospect of a mistrial whatsoever. Do you have any information about which cases were given to Evans to review and who compiled them? So we know that Brearey and Jayaram were passing cases to Dr. Evans. That's the first thing. We know there's another gentleman, was he called Yoxall, who was involved to some extent, who was clearly friendly with Brearey because there's an email from him to Yoxall at some stage. I don't think anyone fully knows the process involved in passing the cases. We know snippets of information, but we don't know the full process because the police are not transparent, so they don't tell you. They've just told. It's fortunate that we know bits and pieces because they've revealed stuff and there's been stuff in the Thirlwall inquiry, but I don't think we know the full picture of how the cases were selected. We can only infer this from the information that we do have. Also, why does Evans keep saying that he was given or asked for all notes of all babies who died or collapsed between January 2015 and June 2016, yet the first case he reviewed was baby G, who was born at the end of May 2015. He was looking at an in date of birth order. Baby B came next in that sequence. Do you think that he was only given cases between June 2015, and June 2016, and those which Lucy could be linked to in some way? He always says he asked for rather than he was given cases between January 2015 and June 2016, and never mentions any from the first half of the year. I think the simplest way to answer that question is simply to say that Dr. Evans is what is often described in literature as an unreliable narrator. So anything that he says, I just wouldn't give any credence to whatsoever. I can't really say any more than that without veering into the libelous. I've been very critical of him. I've tried to be fair, as I was saying in the previous interview with Richard Gill. I do try to be fair because I'm not here to assassinate anyone's character, but I think every iota of criticism that I've given to Dr. Evans is justified and backed up by the facts. So I am very critical of him, and I wouldn't trust anything that comes out of his mouth. I can't say anything beyond that. I have heard that when Lucy Letby was moved from night shifts to day shifts, the pattern of incidents followed her. Do we know whether this is true for all incidents or whether it was only such incidents as the consultants deemed suspicious? Was the time frame referred to long enough to indicate a definite pattern? So this would be a good question to put to statisticians. I think I can say firstly categorically that there is no statistical significance or statistical validity in any of the assertions that incidents moved from night shifts to day shifts. It clearly is not a statistically viable pattern. It's just something that they noticed a bit. Also, you have to say, I mean, this was mentioned again in my discussion with Professor Gill. If someone is on shift a lot of the time, then it's likely they're going to be around when incidents happen. The fact that she moved from night shifts to day shifts is neither here nor there. She was still doing the most shifts. We know that for a fact. So it's not. And also, another aspect of this is how you categorize an incident. So, again, we discussed this in the previous interview. We very much strongly believe, that this chart has been derived by working backwards from a kind of initial premise or hypothesis rather than working forward. So when you do that, the incidents following Lucy Letby is inevitable. So that kind of answers the second question. it really is a case of which incidents are deemed suspicious, not so much by the consultants, although they played a significant role in this as well, but also by the person who ultimately determined what went into the court case, which is Dr. Evans. So the idea that incidents followed Lucy Letby is poorly founded in the first place. It also should be mentioned briefly that there were comments made on several occasions that there seemed to be an unusual pattern of incidents happening at night, but this is known to be a phenomenon. That there's plenty of published research that indicates that you tend to get more deaths at night, and there are known reasons for this. It seems that the paediatricians at the County Chester didn't know this, but I just wanted to make that point briefly. What can be put in place to protect nurses and other healthcare workers from these types of accusations? Nurses in particular seem very vulnerable. I'm very disappointed that Lucy's Union and Professional Association did not come to her defence. So I will deal with the latter part of that comment first. Undeniably, nurses are particularly vulnerable. It's clear that the people at the bottom of the food chain get hammered. They tend to be around the patients more for various medical reasons, and they are clearly very vulnerable. That's, I think, quite obvious. I completely agree with the comments on Lucy's Union and Professional Association. I think it is disgraceful that they abandoned her completely in her hour of need and provided absolutely no support whatsoever, just because I assume they decided, oh, we could end up looking really bad here. I mean, the institutional failures in this case are overwhelming. I mean, I personally, I kind of felt this before, but since I've been investigating this case and researching it, I've just had this overwhelming feeling. I don't think it's really going to go away, that I just don't want to live here anymore. Like, I've lived here a long time in this country, and I've just had enough. You know, you get sick of it after a while. And I understand people say, oh yeah, it's not any better in other countries. I understand that. I understand there's a lot of corruption all over the world. But I've been here for decades, nearly 50 years, and I've just had enough. I've had enough of the corruption. I've had enough of the lies. I've had enough of the institutions. I've had enough of the intransigence of this in this kind of situation. That I don't even want to go into that kind of political issues. Obviously, it costs a lot of money to live here. It's becoming extortionately more expensive to live here. What do you really get for that? I'm yet to see any particular evidence that in this day and age it's something special. Perhaps historically it was. I don't think it is now. I see really massive economic problems. I mean, they're bad now, but I can only see them getting worse based on what I've seen. And of course, the weather's not great. So, I mean, it's actually very warm. This has been a very pleasant spring today. It's very humid, but when I went to Croatia, I just fell in love with Croatia so much, and I just reflected I could live a much better life there. Whether I'll ever live there, I don't know. But I mean, I'm just sick to the back teeth of Britain, and I've had enough of it. And I think Lucy's Union and Professional Association failing to come to her defence is symptomatic of everything that's wrong with this country. It's just a complete dereliction of duty, because it wasn't the done thing for them to do that, and they thought, oh, we could look bad. We need to handle this in a PR way, not actually do what the right thing is morally and ethically, and do what they should have done, which is support her and find out whether the allegations were true. So, yeah, I think it was beyond disappointing. I think it was disgusting and disgraceful. In terms of what can be put in place to protect nurses and other healthcare workers from these types of accusations, that's a very difficult question. What I will say, firstly, is that what is being proposed by the Thirlwall inquiry, seemingly, according to a recent Guardian article, according to what we're seeing come out now about they're going to use AI to identify incidents, and according to the narrative of the Thirlwall inquiry, is collectively absolutely disastrous for the healthcare system and disastrous for nurses. I mean, it could frankly just lead to the complete collapse of the NHS, because I can't see why you'd want to be a nurse. You would certainly, you don't want to be around vulnerable patients. But even if you're not, as soon as you're asking technology to make decisions, I'm always very wary of, because my favourite writer is Philip K. Dick, who's a science fiction writer, perhaps most known as writing the novel on which Blade Runner is based, but generally just a complete genius, an incredible, a person with phenomenal foresight of society and an incredible ability to think up interesting ideas and express them. But Philip K. Dick's work very much focuses on this commingling between corporate power, state power, and technological power. Similar in a way to something like Black Mirror by Charlie Brooker. In my opinion, Philip K. Dick's on a completely different level. I respect Black Mirror and I respect what Charlie Brooker's doing, but also Philip K. Dick is doing this in the 1950s and 1960s in an idealized American society where they're being told, oh, corporations will make life great for everyone. You know, that's literally the message that was being communicated. Whereas Philip K. Dick was always saying, yeah, be very wary, be afraid, you know. And had an incredible foresight for seeing how society could develop, and I think was very accurate with his portrayal. So because he's my favourite writer, and also George Orwell had a significant influence on me, I'm always very wary of this commingling of technological power, state power, and corporate power all together. And we're seeing that now being proposed for the healthcare system. The whole Horizon post office inquiry is essentially rooted in that kind of incestuous relationship. And I think the whole direction this is going in is extremely dangerous, to say the least. In terms of what can be put in place to protect nurses, firstly, that just all needs to be rewound and stopped. Secondly, it probably would help to have CCTV on the units. I don't know if it's a silver bullet, but it would definitely help. In Lucy's case, it seems that it would have helped a lot, because we would see, for a lot of these incidents, the prosecution can't even really properly place her at the scene of the crime. So we would just see that she wasn't at the scene of the crime, etc. So that would really help. I think probably a kind of healthier NHS culture that is not so hierarchical would be probably the biggest thing. That's obviously very difficult to implement by its very nature, because the NHS is hierarchical, because there are different people at different levels with different levels of responsibility and different income. But the nature of hierarchical institutions is that they typically produce this kind of outcome. They as soon as you have hierarchies and you have unaccountable people and you have less accountable people, you see what you see in this scenario, where the people who are held most to account are those at the bottom, and you see the whole mechanisms of the system come bearing down on those at the bottom, like a hydraulic press almost. And that really is ultimately the main thing that could be done to protect nurses and healthcare workers, is to reframe this culture so that it's not as hierarchical and the people at the bottom don't just get shit on all the time. But as the entire history of this country is, probably, to be fair, the entire history of the world, but certainly the entire history of this country is absolutely dominated by examples of hierarchical structure, and the poor, the disenfranchised, the vulnerable, the people at the bottom being shit on, I'm not hugely optimistic that anything will be put in place to protect nurses. However, it's possible that CCTV could make a significant difference. It's essential that we rewind what is being proposed by the Thirlwall inquiry and these suggestions of involving AI in these decisions, because the police don't understand this technology, the lawyers don't understand this technology, the government doesn't understand this technology, the legal system doesn't understand this technology, juries don't understand this technology. There really is a very small percentage of the population that understands AI. I've always been a tech-oriented person. I've done a lot of technology writing. I don't fully understand AI. I have a pretty good impression of it because I'm a chess player, and AI has been very important in chess. So I do have a pretty good understanding of it compared to the average person. But I don't fully understand that. I mean, AI has done some already quite creepy things, such as teach itself its own language. It's created a language. People perhaps don't know this, but AI has created a language itself and taught itself that language, for example. Now, I'm not really one of these people that is concerned about AI becoming sentient and taking over. I don't see any prospects of that happening whatsoever. I don't want to go into that in this video. It would get quite long. But I do think involving artificial intelligence, so-called artificial intelligence, which is just really extremely fast processing, it's not really intelligent. I think involving that in decision making and increasing the scope and increasing the scale and involving it in important systems is very dangerous for numerous reasons. It's partly because of a lack of understanding among people that are working with those systems, and partly because AI is involved with patterns. It uses patterns, and once it has a pattern that it is relying on, and it believes that pattern to be accurate, it cements that pattern, then it will repeat that pattern over and over again. I shouldn't need to explain why that is dangerous in this sort of situation. I think I've asked this before, but the thing that confuses me most is how the pathologist and coroner verdicts could be ignored. Have those coroner verdicts actually been overturned officially now? So I suppose the short answer to that question is yes, because Lucy Letby is in prison and the coroner and pathology verdicts exonerated her. So that has been overturned in the court case, and the machinations of Dr. Evans have been allowed to completely overturn these verdicts. I agree with you that it's confusing. I think what it all really comes down to is that the police in particular cannot understand science or medical matters. So they have run what is a deeply unsatisfactory process, and they just simply do not understand that and cannot understand that. What needed to happen, if anything, was a multidisciplinary review run by extremely qualified people who are working in healthcare now, probably affiliated with the top healthcare bodies. If anything happened at all, there's no particular reason why you shouldn't have gone along with the pathology and coroner verdicts. However, if you're going to do anything else, it should have been a multidisciplinary review. Of course, that didn't happen. The reason it didn't happen was because the police had no idea how to run that. So essentially, that's why this has occurred. And yes, they have been officially overturned. Of course, they can be officially reinstated, or the verdict can be overturned. But yeah, at the time of writing, time of speaking, it's fair to say that they've been officially overturned. This has also baffled me also. If a coroner's outcome states natural causes or even negligence, can the police ignore this and charge someone with murder at a much later date without first requesting another inquest? I've just asked ChatGPT, which informed me that they can indeed. I've quite a detailed answer which suggests circumstances where this might happen, with particular reference to the Lucy Letby case. It somehow doesn't seem quite right, however. So the answer to this question, firstly, is that the police have a lot of power. Essentially, the power is invested in them by the state to decide whether or not a crime has occurred, and whether or not this crime merits investigation. So once they decide to move on something, they can overrule a coroner's outcome, simply because the coroner doesn't have the same level of legal power as the police. Even though the coroner is probably vastly more qualified than the police, and arguably vastly more intelligent than the police still have the power to overrule the coroner. So they can do that. Simple as that. Even if they're completely wrong, they still have the power to do that. It's like any scenario. You see all kinds of unethical things happening. You see all kinds of things in the world that are undesirable. But there's a matrix of power that can justify those outcomes. And in this case, the police, Cheshire Constabulary, they decided, right, we're going to investigate. Initially, when the case was passed and they weren't going to investigate, then they decided to do it. I'll be tackling this later in the video as well. So once they decide to investigate, they then can overrule the coroner. It's as simple as that. Whether or not it's intellectually justified, whether or not it's scientifically justified, whether or not it's medically justified, they can do it. That's all there is to it. And then once it goes to the court system, it becomes reality. And then you've got a big job overturning it, because the court system, as we have seen, will hold. They put what happens in the court on such a pedestal that what has happened in actual reality can now be said to matter less than the court system. They will literally say, well, it happened in court, so therefore what happened in actual reality doesn't matter. And that, I think, is part of what I would describe as a general discriminatory attitude, whereby, and this is just my opinion, this is not a fact, I want to be clear on that, I always have the impression, the very distinct impression, that people working in the court system at a high level view it and convey this in their communications, that this is our system for us to preside over you, the general population. I'm sure they would deny that, but there's a very famous quote by the judge in the or a judge. I'm not sure the precise identity of this person, the Birmingham 6 case. I could dig this up, but a lot of people have seen it already. And he says words to the effect of, yes, there are innocent people in prison in the Birmingham 6 case, but think of the damage we're going to do to the system if we overturn it. And he gives all these examples. And he literally considers that to be more important than the liberty and freedom of the people that have been wrongfully convicted who are completely innocent. Now, no one would make such a gauche public statement as that today, but I think that attitude is very prevalent. Absolutely. I see no reason that it will have changed. And typically the people in the court system, typically from a privileged background, typically they went to public schools, usually very good public schools. They have a very privileged education. Then they do the bar exams. Then they're called to the bar. They mix with people of their own ilk. Look, I'm not going overboard about this, but I do believe fundamentally there is a demarcation, a divide between the judiciary and the general population. I don't think that's a controversial view. Perhaps some people do, but I don't. There were 17 deaths in the time period when it was alleged that Lucy was harming babies. She was only charged with 7 murders. We keep hearing how the average deaths on the unit were around 3 or 4 per year, so 10 deaths still seems like an NHS scandal to me. Do you think this is deliberately ignored by Thirlwall, as it obviously highlights the horrific state of the unit and it would show the hospital to be more deadly on their own than Lucy was apparently? So the first thing is there's 18 deaths actually during this period. And just simply to answer this question, Thirlwall systematically ignored any and all evidence that contradicted the predetermined narrative that it was going to follow from day one. And there's no doubt that this was deliberately ignored. All of the context about the unit has been deliberately ignored. All of the context that goes against the narrative that there's basically a very simple narrative that comes out of Thirlwall. Everything that happened on the unit is the fault of Lucy Letby at the exclusion of everything else. The management should have stopped her more quickly, and they were in the wrong. And the consultants were brilliant and wonderful. That's basically the narrative of the Thirlwall inquiry. And yeah, absolutely, they ignored their own documents on a kind of epic scale. In terms of so what I will say is that lawyers are trained to do this. Lawyers are trained to put forward a narrative and completely ignore all the contradictory evidence and concoct something that supports their narrative. That's basically what a barrister does over and over and over again. They really have no conscience about whether or not it's right, wrong, or whatever. There's only a small percentage of barristers that will act in support of what is right, and even then, sometimes to make their name and to make their way in the world, they have to support things that they know to be wrong. So yeah, it was absolutely deliberately ignored by Thirlwall precisely for the reasons that you've described, because it highlights the horrific state of the unit, and it would show that the hospital was dysfunctional, and that wasn't the narrative. The narrative was it's all Lucy Letby's fault, and that the manager should have stopped her more quickly. In a serial killer court case, are forensic criminologists normally used by the prosecution? And if so, why were they not featured in Lucy Letby's trial? So I don't know if they are normally used, but I'm sure that they are used on occasion. But I can explain to you now why they didn't feature in the trial of Lucy Letby. So we see here a description of a forensic criminologist. A forensic criminologist applies criminological theories and knowledge to the investigation and analysis of crime, often working with forensic scientists to understand criminal behaviour and provide evidence for legal proceedings. They may analyse crime scenes, interview suspects, and interpret forensic data to help reconstruct events and identify offenders. Key aspects of a forensic criminologist's role: understanding criminal behaviour. Forensic criminologists explore the motivations, psychological profiles, and social factors that contribute to criminal activity. Crime scene analysis. They may examine crime scenes looking for physical evidence, identifying patterns, and assessing the circumstances surrounding the crime. Evidence interpretation. They analyse forensic data, including DNA, fingerprints, and other evidence, to draw conclusions about the crime and the individuals involved. Expert testimony. They may provide expert testimony in court, explaining the significance of forensic evidence and their interpretations of criminal behaviour. Collaboration. Forensic criminologists often work closely with forensic scientists, law enforcement, and legal professionals. Research and policy. They may also conduct research on crime trends, offender characteristics, and the effectiveness of crime prevention strategies. So we don't need to look at that. That's all about education and training. So in this case, a lot of what a forensic criminologist would do is irrelevant because the crime scene was never examined. So the prosecution never examined the crime scene or even the infants. It's just all based on hypotheses and theories. So all the stuff about crime scene analysis and evidence interpretation is just gone immediately. So that applies to the prosecution didn't even attempt to do that, and the defence didn't have any access to the crime scene because it was 9-10 years ago. Sorry, I mean, slight exaggeration. It was 6 years ago when the court case began. So that role of the forensic criminologist is out the water immediately. In terms of understanding criminal behaviour, the prosecution never put forward a credible or plausible explanation of Lucy Letby's supposedly criminal behaviour. And the explanation that they did put forward was tenuous to the point of being ridiculous. So a forensic criminologist would have been more likely to disagree with them than support them. So they were never going to call a forensic criminologist because there is no forensic criminologist that would have supported them. In terms of the defence and why they didn't call a forensic criminologist, I don't know. They didn't call anyone at all. So it's very hard to say what they were doing. But that kind of gives a very reasonable kind of, I think, explanation of why there are no forensic criminologists in this trial. It's basically because it would have been detrimental to the prosecution and the defence just didn't call anyone. I'd love to see some interviews with nurses about the culture of poor relationships with medics. I have known for decades how doctors throw nurses under the bus. It's common knowledge among nursing staff, and I was warned about it in the early 90s. So it's always tricky to get nurses onto the channel because it's very difficult for them to reveal their identity, often impossible. I have thought some ways that I could possibly do this and anonymise them. I always feel a little bit bad to ask. I mean, I would love to do this because I've learned so much from speaking to many nurses now. Unfortunately, it's tricky for the reasons I mentioned, but I have thought of ways that I could possibly do this. I always feel slightly bad for asking them to do something that could reveal their identity, but I think there are ways we can do it without doing that. So I will give this some thought and then maybe ask some people that I know well, would you like to do it? And then we'll see what's possible. It's definitely, I'm glad you mentioned that because it's given me some food for thought, and it's possible that I can do something. It may, in an ideal world, what I would do maybe is record an interview and then re-record the parts where the nurse is speaking with artificial intelligence or, online voices, something like that. I'm not sure I'm technologically advanced enough to do that, or I can be bothered to fiddle with it, so I might just read out both parts myself. That's kind of the low maintenance way of doing it. So yeah, this might happen in the future. I think it's a good idea. I'll just have to approach it delicately and see if it's possible. This may have been answered already, but regarding the insulin cases, is there any record that any insulin was unaccounted for? And if not, where is she supposed to have sourced this? Also, why wasn't Ben Myers all over this? So firstly, I can say categorically there's no record that any insulin was accounted for or unaccounted for. It wasn't in the court case. The prosecution never made this allegation. It just simply never happened. This seems like pretty poor processes from the Countess of Chester, but the fact is it just isn't in the court case at all. If they could have made this allegation, they would have done, and they couldn't. In terms of why Ben Myers wasn't all over this is yet another question that I can't answer regarding Ben Myers. I don't know. But I don't think he ever made any statement such as, look, there isn't even any insulin missing. If I encounter one, then I'll apologise for that statement. It could be incorrect. There's an enormous amount of stuff in this court case, but I haven't seen any from what I have seen. I haven't seen any indication of this. I want to go into the court transcripts in more depth, but there's so much to cover. It's an enormous amount, but I will do that at some point. What about the Liverpool Tube dislodgements? So what I would say about this is that this was never an allegation that was going to go anywhere. It's completely without foundation. It's utter bullshit. It was clear from day one that this had no merit, and the police were never going to advance this. Note as well that the police said, we're investigating 4,000 other cases that Lucy may have been involved in, and then they cut that down to 2. So they ruled out 3,998, and then we've never heard any more about that. Bear in mind, they went to prison to interview Lucy, so they've interviewed her under caution. I don't think they arrested her as such. So that's just going to, in my view, this is just a shield to protect the police from further examination. But we'll get into that later in the video. Hopefully there's not too much more to go, not too many questions left. Have you analysed the cross-examination of Dowie Evans by Ben Myers? I haven't done this yet. It's on my to-do list. It will happen at some point. I want to get back in to do the closing statement. I've done several things. I've made several videos now where I've made one video, and there are many, many videos to come, and I haven't continued the series, so I do want to go through some of them. I've only done 3.5% of the closing statement of Nick Johnson. That deserves much further analysis, so I will be doing that again soon, probably next week. Possibly I might do it this week. We'll see. But yes, I will definitely analyse the cross-examination of Dowie Evans, and I'll be doing a lot more court transcripts in the future. With regards to Brearey, I think his actions are extremely questionable. He's asking us to believe that just because Lucy was present for a lot of the deaths, but despite him knowing that she worked more hours and was often given the sickest babies, this made him convinced she was a murderer. If he was just basing his gut feelings on commonality, why, when Dr. Harkness features prominently on the staff rota chart, did he remove all doctors from the chart? So what I will say to this is, I can't discuss the full context of this at this time for several reasons. The whole story of this is in my book in greater detail than has ever been written or published or spoken about anywhere else. And that also applies to the chart, and I've got some inside information on that. I can't discuss that at this time for various reasons, and actually today would be the worst possible time to discuss it, I think, but we'll come to that in a minute. I'd love to know what people think about all the handover sheets she kept at home and apparently even moved house with them. I think she is innocent, but I find the handover sheets in her house, particularly the number of them, very odd. She would have had many opportunities to have gotten rid of them, either in hospital confidential waste or at home by shredding them. So the first thing I'll say is that it's not uncommon to take handover sheets home, quite the opposite. So the presence of these handover sheets at home are not of any relevance. I think I agree with you that the number is quite a large number. Other people who are more qualified and other nurses would need to comment, but there was a large number. But this firstly shouldn't be seen as anything sinister, because they can easily just come home in clothing. And in the near future, I'm going to look over a part of the court case where a paper towel was discussed. And it's just very clear that this is something Lucy had in her pocket and she took it home by mistake, and then she didn't dispose of it because you can't just throw it in the bin. And she never got round to shredding it, so she just stuffed it under her bed because she's a busy person. In an ideal world, she would have shredded it. And the ironic thing is, she could have shredded so much of the evidence from this court case, but didn't, because she thought it was of no significance. That in itself is an indication of innocence, but the prosecution have obviously tried to use this against her. Some of the cross-examination is frankly surreal, so I would like to go into that in the near future. There's so much to cover from the court case, of course, but I do agree with you that there was a large number, but this can just happen because she did a lot of shifts, she put a lot of documents in her pockets, then she took them home, then she found them, then she realised they were confidential, she didn't know what to do with them, she never got round to it. The point is, this is nothing to do with murder. Most of these handover sheets are nothing to do with the case. Most of the infants in the case, or a certain number of the infants, did not appear in the handover sheets at all. This was just something that was used as essentially as smear tactics by the prosecution, regardless of the number of them. And certainly the allegation and the insinuation and the explicit comments that Lucy Letby kept these handover sheets and kept other documents as some sort of souvenir or trophies is just laughable when you look at the actual evidence. The evidence clearly indicates that that's not the case at all. This was just something that the prosecution had to put forward in a kind of vague attempt to put forward some sort of motive or to try and smear her character to some extent, because these are motiveless crimes that don't make any sense at all. So the prosecution had to do something, and the police as well wanted to put something into the case that they'd actually done, because they did nothing for the medical evidence because they don't even understand it. So it's like, oh look, we found some stuff at our home, we can put this into the prosecution case, and the prosecution case has kind of used this creatively. I personally do get asked about this a lot. It's probably the thing that comes up the most that people talk about, who don't believe that she's innocent as well, who believe that she's guilty. For me, it's just laughable in terms of a piece of evidence, and I don't take it remotely seriously, but clearly some people think that it has some sort of significance. I don't know what to say to those people except to debunk it over and over again in as many different ways as possible. They still keep coming back at me and asking about it, so I don't know what else to say. All I can say is this is not an indication of murder. It's not even really an indication of being a bad nurse. It's perhaps an indication of being forgetful and then being too busy to shred the handover sheets. She should have done that, and she can be criticised for her professionalism with regard to that, I suppose. But it's not a big deal, and it's certainly nothing that indicates murder, and it's not really a piece of viable evidence in the court case. It's just something that's been used, as I say, as a form of smear tactics. Does anyone know, is it possible to write to Lucy via snail mail, I guess? I've got an urge to let her know I'm rooting for her, but I wonder if that's even possible, a good idea. Thoughts? Well, firstly, I think it's absolutely fine. I don't know if it's a good idea, but it's not a problem. If you want to do that, then I would encourage you to do it. What we can say is difficult to get information through to Lucy because of her very high status as a Category A prisoner. But it's certainly possible to write to her. The prison that she's held at is known commonly. It was reported on very recently. So I think there's no harm in doing that. You just may never hear back from her, and you may never know whether she's got the letter. But please do feel free to write to her. I'm sure that she would appreciate that if indeed she received a letter. I wonder where the responsibility lies, whose feet should be held to the fire in this. Brearey for coming up with such a misleading chart in the first place, Evans for discounting other death cases purely because Lucy wasn't there, maybe the CPS themselves for getting Professor Jane Hutton stood down just before she was going to tell them everything was wrong with the chart. So, in my view, the person who is most responsible for this is Dr. Evans, because I'm doubtful that you could get any other neonatologist anywhere in the country, with the possible exception of Bohin or the people that are in the National Crime Agency, but it would be very, very difficult to get anyone to go in there and say what Dr. Evans has said in this court case regarding the injection of air in particular. So I think he is the most culpable because he's been the person arrogant enough to overturn pathology reports, coroner reports, and natural causes for all these infants, and failed to account for so many different factors, and failed to do proper diagnoses, and failed to do proper medical and scientific work, and put stuff in the court case that is total rubbish. There undoubtedly other people should be held accountable as well. The consultants are one group, the police are another group. They failed to do the due diligence. I can't talk about the consultants too much. CPS, obviously, it's very strange what they said about Professor Hutton. We discussed this with Richard Gill recently, so it seemed that they believed that the jury couldn't understand the statistics, but then they put statistics in there anywhere, but just not produced by a statistician. The CPS, obviously, I think generally is just not fit for purpose, in my opinion. And the police should have done their due diligence on Dr. Evans. So there are several groups that need to be held accountable for at least 4 separate. I think the judge as well made some very strange decisions, and also when Lord Justice Jackson wrote to Goss saying this Evans character is a bit dubious, and very explicitly outlining the problems with him. That's not something that happens lightly. That very rarely happens. It's a fairly extraordinary intervention. And to just ignore that and say, oh, it's fine, we'll just carry on anyway, even though Dr. Evans is 95% of the prosecution case, is very, very difficult to defend, in my opinion. So that will be a fifth party. So I think the consultants, the police, Dr. Evans, the CPS, and the judge should all have serious questions to answer. How many of those will end up answering serious questions, I'm not sure. But I'd say Dr. Evans is potentially very vulnerable because he doesn't have any friends, and he can be made very vulnerable very quickly. They can toss him overboard rather easily. So he is the most vulnerable, undoubtedly. And the last question is from someone who I think believes Lucy Letby to be guilty. So I was happy to take questions from guilty people. Why did she say she was going to go in with a bang when referring to going back to work after being on holiday? So this is just simply a stock expression that anyone would use. If you're going to say you're back with a bang, it doesn't mean I'm going to be back with a bang and I'm going to murder some babies. It's just it's a generic expression that means there's going to be a significant impact when I come back in. And all she was referencing was the fact that they had a lot of very ill babies on the unit. We know that they gave Lucy the sickest children in many cases, and she's referencing that. I would ask people to consider as well, it doesn't even, if she was referencing the fact that she was going to go in and murder infants, it doesn't even make any sense, because why would she do that in a message with a fellow nurse? Essentially, she'd be incriminating herself. Not that there is any meaningful reference to any murders here. This is just a stock phrase that's been used millions of times in numerous different contexts, and is essentially just completely meaningless. But it'll still be used in a courtroom and put on a pedestal because, that's the way the criminal justice system works. So that was intended to be the end of this video, but I want to comment finally on this news that's broken today, literally while I was recording this video. 3 bosses at Lucy Letby Hospital arrested on suspicion of manslaughter. Unnamed 3 from Council Chester Hospital held on suspicion of gross negligence manslaughter, police say. So these people haven't been named yet. So I won't speculate on who it is. I believe that I know who it is, but I won't comment on that. I'll just quote this statement here from Paul Hughes, the infamous Paul Hughes. In October 2023, following the lengthy trial and subsequent conviction of Lucy Letby, Cheshire Constabulary launched an investigation into corporate manslaughter at the Council Chester Hospital. This focuses on senior leadership and the decision-making to determine whether any criminality has taken place concerning the response to the increased levels of fatalities. In March 2025, the scope of the investigation widened to also include gross negligence manslaughter. This is a separate offence to corporate manslaughter and focuses on the grossly negligent action or inaction of individuals. It is important to note that this does not impact on the conviction of Lucy Letby for multiple offences of murder and attempted murder. As part of our ongoing inquiries, on Monday the 30th of June, 3 individuals who were part of the senior leadership team at the Council Chester in 2015 to 2016 were arrested on suspicion of gross negligence manslaughter. All 3 have subsequently been bailed pending further inquiries. So I'll just read Mark McDonald's response to this. Both the corporate manslaughter and gross negligence manslaughter elements in the investigation are continuing, and there are... Oh, sorry, this is still Hughes. Because they started to introduce Mark McDonald. Let me just finish what Hughes said. Both the corporate manslaughter and gross negligence manslaughter elements of the investigation are continuing, and there are no set timescales for these. Our investigation into the deaths and non-fatal collapses of babies at the neonatal units of both the Council Chester Hospital and the Liverpool Women's Hospital between the period of 2012 to 2016 is also ongoing. So Mark McDonald, barrister at Thirlwall Chamber, said, yet another press release from the police at a very sensitive time when the CCRC are looking at the case of Lucy Letby. Despite this, the concerns may have raised will not go away, many have raised will not go away, and we will continue to publicly discuss them. The reality is that 26 internationally renowned experts have looked at this case, and the lead experts concluded that no crime was committed, no babies were murdered. What is needed is a proper and full public inquiry into the failings of the neonatal and paediatric medical care unit at the Council Chester Hospital. So with regard to this, I would firstly state that I mentioned earlier in this video that the police were supposedly investigating 4,000 cases. Now, they eliminated 3,998 of these cases and said, oh, 2 of them are ongoing. And they're still saying here, oh, we're still investigating the non-fatal collapses and deaths at the Council Chester Hospital and the Liverpool Women's Hospital between the period of 2012 to 2016. So it's 9 years now since this case was passed them. 8 years, in fact, I should say. They've had this case for 8 years. And they're saying, oh, there's no time scale. There's no set time scale for this. So in my view, this is just a shield to prevent them from having to answer any questions or to be held accountable in any way. I don't think for 1 second that these executives are ever going to be charged. Just as they questioned Lucy Letby in prison, and she voluntarily participated and cooperated with that questioning, and they've not charged her, and they say, oh, it's still ongoing though. It's because they're just trying to shield themselves against criticism, because they know at this point that their investigation was a complete shambles. It's possible that they're so stupid they don't know that as well, but they're trying to protect themselves against criticism because there has been enormous criticism because of all these experts coming out. I can't go into the full details at this point in time for numerous reasons, but in my view, there's no prospect of these people being charged. I can't say that categorically, of course, because there's always a chance, but I really think that's extremely unlikely given what I know about this case. And the idea that they're still investigating deaths and non-fatal collapses when the court case is finished. The court case finished 2 years ago now. The investigation began 8 years ago, and the actual collapses happened 9 years ago. And the tube dislodgements are completely lacking in credibility. They have no credibility whatsoever. I can't see that this is happening for any other reason than just to protect the police. So the police don't have to answer questions. They can just say, oh, we can't say anything due to the ongoing investigation. So their aim is just to keep this investigation as ongoing as long as possible, so that they never have to answer any questions. They're trying to prevent themselves from being held accountable. That's crystal clear. So I just want to finally finish this video by just showing you one thing. So this is document INQ0003077 from the Thirlwall inquiry. This is an initial meeting of the Cheshire Constabulary in relation to Operation Hummingbird. I've shown this before. This document contains this comment about Lucy Letby, there being a statistical relationship, and then it says there is no evidence other than coincidence. So when this case was passed to Cheshire Police on the 5th of May 2017, there was literally no evidence that there had been any crimes at this hospital. And there are numerous other statements from the Cheshire Police at that time indicating exactly the same thing, until something occurs that I'm not going to discuss today because there are ongoing issues related to this that I can't get into. But this indicates very clearly that when this case was passed to the police, referred by executives at the hospital, the police acknowledged that there was no evidence. So what are they going to say? Are they going to say, right, well, you should have referred this to us a year earlier when there was still no evidence? That's hugely negligent. It's laughable. There's absolutely no way this could possibly result in a court case, because we've got all the documents from the Thirlwall inquiry that show that this was passed to the police with no evidence. So how can that possibly be negligent when the police themselves have acknowledged that initially they had absolutely no intention of investigating any further? And then there's been an article here from Sarah Napton in the Daily Telegraph, where the headline is a bit clickbaity because they want as many people to click on it as possible. I don't think the arrests necessarily are bad news. It's certainly not helpful, but she discusses this and she discusses the allegations, and I think there are key paragraphs here. For the police to not only refuse to acknowledge the serious doubts that have arisen since Letby's conviction, but to also double down by arresting the management feels not only tactical, but a little vindictive. After all, if the CCRC determines that the conviction is unsafe and Letby is eventually acquitted, a very real possibility, then a decision of management to question the suspicions of finger-pointing consultants will be entirely vindicated. It is also hard to see how the management team could have acted differently when consultants came to them claiming that a killer nurse was on the prowl. Evidence to the Thirlwall inquiry, which is looking into how the attacks could have been prevented, revealed that doctors provided no proof that Letby was guilty, simply having a gut feeling because she was present when some of the babies collapsed. So I won't go into that any further. I certainly can because I examined every single document that's submitted to the Thirlwall inquiry. There is a very detailed analysis of this in my book. There is a reason that I can't discuss all of this currently. I can't discuss what that reason is. All I will say is that I endorse the view of Sarah Napton here. It's fairly extraordinary that we have a mainstream newspaper saying the police are just doing this for tactical reasons, and it's essentially not a legitimate thing to do, and they don't really legitimately believe that there's going to be a charge here. I'm really glad she's written that. It's a very bold thing to do, and I think it is really massively to the credit of the Daily Telegraph. I, of course, entirely agree with her view. I think this is entirely frivolous. In fact, I know that it's entirely frivolous. I know these executives are completely innocent of these charges. It will be interesting to see what develops, but very difficult to predict at this time. What I will say is that I'll be extremely surprised if they're charged, because I can't see the court case being anything other than a complete disaster and embarrassment for the Cheshire Constabulary. So that's the end of this video, and that's all I have to say on this matter, and all I can say at this point in time. I hope you've enjoyed seeing me address these questions. I definitely will do another one of these videos in a couple of months, because I think it's a good way to interact with people that have supported me. If you have any comments, queries, observations, or anything else, please do leave them in the comments.